Good afternoon, everyone, and good morning to those of you joining us from the West Coast. Thank you for tuning in and spending the next hour with us. I'm Jeff Rizzo, Senior Vice President of Arch Insurance Group. I also have with me David Ericksen with me. David is a senior partner with Murtaugh, Treglia, Stern, and Deily LLP. He has a great topic to discuss on the 5 C's of design teams: contracts, communication, coordination, cost, and closeout. I will be turning the webinar over to David shortly. However, I would be remiss if I failed to mention that this webinar is a team effort and is sponsored by Arch Insurance Company in conjunction with PUA. PUA is our managing general agency that represents Arch. They are a longtime partner and, quite frankly, in my opinion, the best team at underwriting and servicing architects and engineers and design build contractors, professional liability accounts in the industry. We are also recording the webinar, so we will be sending a follow-up email with a link to the recording as well as a PDF of the webinar itself. Now, in terms of CE credit, this webinar includes 1 hour of CE credit for all licensed architects and engineers that attend. Unfortunately, insurance agents that I know that we have a lot of here today are not eligible for the CE credits. However, I'm still extremely confident that the time that you have here with us during this hour will definitely be time well spent. Now, a quick overview of PUA. PUA was founded back in 1990 by PUA Program Director Sandip Chandarana's father, Ram. They have a proven track record and offer stability and deep expertise with collectively over 100 years of underwriting experience. They write more than $65 million in gross written premium and service over 1,500 policyholders. They focus on 4 main lines of business: architects and engineers, design build contractors, miscellaneous professionals, and excess as well. The one thing that PUA is really excited to announce that they now have the ability to offer excess professional liability coverage on an admitted basis in 34 states for architects and engineers and design build professional contractors. As I mentioned earlier, PUA works very closely with Arch, but they also have access to Lloyd's. So for some of those harder to place risk that outside of their core program with Arch, they do have a solution for those as well. In terms of risk management services, they also said that that's something that really helps set them apart. They hold webinars such as this throughout the course of the year with industry experts and that offer CE credits. And again, this is just another value-added service to their agents and insureds that help really set them apart. Additionally, they have a huge library with a bunch of the webinars that they have done in the past, and that's listed there on the screen. They recently launched the new website, PUAinc.com, so please be sure to check it out. Utilize all the resources that they have available within their new website. Finally, in it briefly about David. David has repeatedly and successfully represented design, construction, real estate, environmental professionals in jury trials, arbitration, as well as mediation and other forms of alternative dispute resolutions in state and federal courts. Additionally, David, expert in professional liability and risk management, and we are extremely grateful and fortunate to have him here with us today to share his knowledge and expertise on a great topic that he's put together for us. We're really all in for a treat, and without further ado, I'm going to hand it over to David now.
Well, thank you, Jeff, and good morning, good afternoon, wherever you may be, or wherever you might be watching this in the future recording as we go through this. I want to give just a little bit of a further snapshot for how I come to this adventure and to share with you. And where that comes from is I have now been blessed to be practicing with design professionals for about 35 5 years. I guess it's 34 years at this point in time. And in that experience, I started out doing heavy litigation, just nothing but litigation, condo litigation, residential litigation, school litigation, all that sort of thing. And as I went through that, I would feel like I was learning the lessons, learning the train wrecks of the projects. And as I evolved, I wanted to become more a part of the solution. And so now for about the last 25 years, I spend about half to 2/3 of my time in litigation. I just completed a trial in Los Angeles representing a structural engineer. But I then go forward and I try to take those lessons out, the lessons for the community to learn to do better and actually to avoid those claims that I'm talking about. And so as we go through all of this today, we're really talking about the core elements as I have seen it for successful design teams. And as Jeff talked about, that is contracts, communication, coordination, changes in costs, and then closeout. And if we can keep our eye on the ball on those, account for those, and work together collaboratively and strategically for those issues, the reality is we are going to have successful projects, we are going to make money off those projects, and we are not going to end up in that litigation context that we're talking about nearly as often as we do. And when we do, we are going to be much better equipped to deal with all of that. Now, as I said, my lessons largely come from the litigation world, defending the architects and engineers, going through those miserable claim experiences, those distracting, those depressing claims that come through, and trying to solve those. And so I've taken this example as our starting point because it's, to me, a classic example of what happens within a team. And this happens to be a situation where I represented an architectural firm of national standing, one of my longtime clients. They've been my client for somewhere in the neighborhood of 25 years, and I'm honored to represent them. But a national firm, and one of their areas of true expertise was in the area of higher education. They have done some of the most spectacular higher education projects in our country, literally. And as they did so, they really did it instinctively. They did it because they knew how to do it. They had a sense of where to go, how to do it, and particularly the more seasoned and experienced architects could lead that effort through to what was going on. And so a new opportunity came up for them. And as they were looking at that opportunity, it was going to be what they thought was really exciting. It was a little bit different because instead of a four-year university or a graduate school university, it was a community college campus. But for this urban community college campus, they were going to become engaged not just with one, not just with two, but 10 separate buildings. It was going to be teaching buildings. It was going to be performing arts buildings. It was going to be office buildings. And because it's what drives any campus, it was also going to involve a parking structure that would have an athletic field on top, and in an urban setting, ironically, an adjacent golf course driving range, very similar to what you might see in Top Golf. But for them, it was an exciting project to be a master planner, to be working in their community, to have multiple project opportunities looking forward at it. So this is the project that they were looking at in terms of, the visual of this project. The site layout for this had a number of different projects around it, and I'm not sure if we are seeing the correct slide here, because I would have, there we go, right there. That's the one that we're looking for. So this was our site. And it was so exciting because each site building here that has a number on it, that was going to be a new project for them. That was going to be a new building, an opportunity to remake this entire campus. Well, there were things called budget cuts, and there are issues called funding issues, and then things like that. And ultimately what happened on this project was, instead of those buildings, this was the part of the project that was left. It's a parking structure, 3 stories above ground, 1 story below ground, with a lovely athletic facility on top, a track and all of that. And then adjacent to it, as I said, of course, what every urban community college campus needs, a golf course driving range with a Top Golf driving platform type structure associated with it. Well, as you might guess, my national architectural firm, they weren't specialists in parking structures. They weren't specialists in athletic fields, particularly on top of parking structures, and they weren't specialists in golf course driving ranges. But because they'd signed on to be the prime, because they wanted to go forward, they went forward with it. And essentially, they subbed out the design of what became 3 projects to 3 separate sub-consultants. They subbed out the parking structure to one entity. They subbed out the design of the athletic field on top of the parking structure to another entity. And they subbed out the golf course driving range to yet a 3rd entity. Well, David knows about this because that didn't go well. In that context, this one of these C's we've talked about, the coordination simply did not take place. The water didn't have a vehicle to get off the athletic field through the parking structure. The golf course driving range towers for netting that were going down deeper than and adjacent to the parking structure weren't coordinated with that, and there were disruptions and failures there. All in, what it resulted in was about a $7.5 million claim against my architect. We tried to solve it, but the further problem beyond the coordination issues was that their contracts themselves were not coordinated and were often missing. There was an agreement with the university that was on their unique form of agreement. Then on top of that, there were 2 sub-consultant agreements, but one of the major sub-consultants wasn't even under contract, and the 2 sub-consultants that were under different forms of agreement. One of them calling for arbitration, one of them calling for federal litigation, while the university's venue for resolving things against the architect was state court. So as you can imagine, it led to a number of issues that we had out there and how we drove that forward. So our agenda for today is to try to figure out how to solve where we are. So if we can go back 1 slide. These are really the 5 issues rather that really drive it. I love alliteration because it helps me remember things, but it really is the checkbox, if you will, the checklist, to add another C to it for you, of where you can go in working as a part of a team, putting a team together, or leading a team in terms of providing a competent and good project delivery model. The contracts are your roadmap. Your contracts are your agreement, but the contracts are only the starting point. I, as a lawyer, get obsessed about contracts, but they're only a starting point and they're a roadmap. And then we need to work together and work well through communication and coordination. We need to manage those issues of costs because, to paraphrase my friend Glenn Closeout of The Natural, there are 2 projects. There's the one you contract for, and the one you live with after that, with all of the changes and costs. And that can create great acrimony amongst the design team if we don't have a plan. And then we need to close it out. We all need to move on with life, and we need to close out the project for our collective ease of mind and going forward into the future. And so we're going to walk through these today. Quite literally, each one of these topics could be a full hour seminar. And if there's one or more topics that you think would be a great follow-up session for your PUA Arch team to deliver to you, please put it into the question or comment box. They'd love to hear from you because they want these seminars, these webinars, to be valuable and important to you in terms of what's taking place. So let's talk about contracts. And particularly in the context of our design team, there are some real challenges to the contracts. There is the 2 challenges that we really have of vicarious liability and joint and several liability. And I want to explain those because those sound very legal, ease type things, but it's important to understand them because one of the key elements of your contract is risk assessment and risk management. Vicarious liability is something that is incredibly important to the primes on any agreement. And what that means is you are vicariously liable for all of those that you retain on the project. Their responsibility, their financial exposure, the owner's rights against them, the client's rights against them, flow up and down through you. And so if a sub-consultant does something wrong, you can be independently financially responsible for that. The same thing with respect to joint and several liability, but it's a little bit different and particularly a concern for sub-consultants on a project team. What joint and several liability holds is that if multiple people contribute to the harm, then the injured party can recover all 100% of their damages from any one of them. And so if we have an issue in coordination, say between our structural and our mechanical design that should have been taken care of, well, they could recover 100% of their damages from either the structural or the mechanical or probably the architect who is responsible for overseeing it. So this is an example of that. This is the bar chart that kind of oversees all of that and how we manage that. And so it's important to have the contracts and the insurance and the provisions to both contain these risks and then to manage these risks as we come and we go into the future of what we are dealing with on a particular project or in a particular team that we have. So obviously one of the common issues that we have, probably the most common issue, is the flow down from the prime agreement to the subconsultant agreement and how that's going to flow. This, guys, is an example of a clause that I've literally had in one of my agreements. In fact, I've had this clause in many of my agreements. And what this says is the consultant as an independent contractor, so I've just declared independence, right? In addition to any other obligations imposed on the agreement, shall perform in the same manner and to the same extent that architect is bound to perform such services to the owner under the agreement between the owner and architect. Can somebody please tell me what that means? Can you tell me where it starts? Can you tell me where it ends? Most often for me, would that incorporate the arbitration clauses, the mediation clauses, the indemnity and defense clauses, or are we all separate and apart from all of that? The reality is that there is no clear definition in this, although it's a very common provision. And so we want to build towards something that has a little bit more flow to it. And so I want to share with you what I think is the prevailing standard out there. It comes from the AIA in terms of their flow down provision. And the great part about this is, and the important part and why I think it's so valuable, is it is a bilateral flow provision. And what it says is, down there in the middle of it, it says the architect shall have the benefit of all rights and remedies and redress against the consultant that the owner under the prime agreement has against the architect, and the consultant shall have the benefits of all rights, remedies, and redress against the architect that the architect has under the prime agreement. That is incredibly valuable. What that does is it creates a bilateral nature, and it is very clear and very specific that it includes the contract terms. But then what happens when the contract terms don't line up? What happens when there's a difference between them? In that clause we just looked at from the AIA, I highlighted in the red words there the language that says that in the event of a conflict of language, the subconsultant agreement will control. It becomes a default. And so if there's a conflict, the subconsultant agreement will control. Now, it's good for the subconsultant sometimes, but it can be literally a disaster for the prime consultant and some of the other consultants on the team. For example, some of the worst examples I have seen, or the more difficult examples, is when the subconsultant agreement for one subconsultant includes a limitation of liability clause, for example, limiting their liability to $50,000 on a $12 million project. In that situation, the architect would be limited to $50,000, regardless of whether or not that party was at fault. And that then liability would flow disproportionately to that party and to the subconsultants also retained across it. And so I actually prefer something that's more intentional. This is the default. This makes it automatic. I want us all to be on the same team. I want us all to be working intentionally together, but I want us to do so strategically and intentionally. And so my provision that I prefer is the provisions of the prime agreement shall control except as expressly set forth herein and as otherwise agreed by the parties in writing. I don't mind changing from the prime agreement, but let's do it open book. Let's do it intentionally, and let's do it with clear communication around all of that. And that, I think, is really, to me, the better way to do it. You can then set it out in your subconsultant agreement. You can set it in your scope of work where the variations would be, but let's just be clear about it. I know it can lead to some difficult negotiations. I've been part of literally hundreds of those, but I think it's incredibly important so that we don't have bigger problems down the road as we go through it. So with respect to these design agreements that we're talking about, you know, this is one literally, again, that we could talk for hours. And I know that your PUA Arch team has some of the best contract review services anywhere in the country. I know the people that do it, and they do a fantastic job. But I want to just share with you just a couple minutes here on, you know, what I think the essence, the importance of a design professional agreement is. And most of this is going to apply either in a prime context where you're agreeing with the owner or the client for the project, or amongst the team members. There are really fundamentally three drivers that I think are out there. You'll notice a different alliteration here. It's about relationships, rewards, and risks. Those are the core things that we have to deal with. And as we deal with those types of things going on, we look at the clauses in the agreement, and they really can be broken down by their dominant functions within the agreement. And as we go through that, breaking that down a little bit more, it's about relationships. It's about preserving and fixing the relationships, the standards that we're going to go through, the procedures. That's really a core part that we're going to be talking through today with respect to communication and coordination. And then the financial rights and responsibilities and liabilities. That goes to the costs, the changes, the closeout of the project as we are working our way through all of that. I am a fan of the 20-80 rule. I take it to be the 20-80 rule, not the 80-20 rule. And the 20-80 rule is I would apply it. First of all, it comes from an Italian economist by the name of Pareto. And so that's why I've called this the Pareto six-packs. And as I go through agreement reviews, and I've done it for PUA Arch, I do it for others, I really try to focus in on the clauses that are going to make the most impact on risk, on financial success, on sanity for what's out there. And so as I've gone through all of that, the 6 areas that I believe are the greatest impact value, those 20% of the clauses that make the biggest impact, are these. The scope of work, that it be limited, it be detailed, it be contained, that we don't have a limitless obligation. Literally, guys, I have had agreements for design professionals that said nothing more than we will design a high school for 1,200 students. Really? How do you know when you got there? How do you know what the standards are? How do you know the satisfaction for there? The standard of care. The standard of care is so important because it guides what you do, and it can be and often is the greatest point of disconnect with your insurance. You are insured for the prevailing standard of care for design professionals providing similar services. Your contractual obligations should be consistent with that and limited to that. And that gets us into the next big issue, which is the greatest departure typically from that standard of care or scope of work. And that has to do with the warranties and guarantees. The first person that can log in and tell us that they've done a perfect project with every detail, every specification, every line, every measurement perfect, great, let us know. But that's not the standard of care. And in fact, expressly under the state law in every state in this country, it says that perfection is not the standard of care unless somehow you agree to it in your agreement. So we need to be wary of anything that would be a warranty or guarantee, and also to disclaim those as we go through all of those. We need to then get into the indemnity and defense, because that is oftentimes at the core of resolving insurance claims and becomes a true issue of contention amongst the design team members. So as we get through this later on, I'm going to recommend a approach to all of that I think makes sense for our design team. We're then going to talk about dispute resolution a little bit, or we need to talk about it. How are we going to solve things? Please don't back yourself into that situation that my poor architect on that community college project was, where they were solo in litigation because they could not join any of their sub-consultants to it because of the team concept and the disparate agreements they had entered into. And then finally, third parties. Your agreement's about a relationship, guys. You get into the relationship, you should be selecting your clients and your teams as much as they are selecting you. And as a result, your obligation should be limited there and not transferable from that. And so we've got clauses out there. There are a number of things that we've written over time. You'll see at the end, there are a number of articles that I've written or white papers that are available to you through PUA Arch. One of them goes through and talks through these 6 principles that we're talking about, and others dive a little bit deeper into some of the issues. So those are the core issues. But then we get into some of the others. And right now, as we're going through these others, I'd welcome you to pop into the chat, the questions area, and just drop in what else you think might be an appropriate point for my Pareto 6, or something else that would be appropriate for the others. Because that 20%, I believe, drives everything. But then we have other things that are out there, and design rights is a huge driver. I'm actually giving a seminar in September on that specific issue, because design rights, clients' demands to have the design rights, the evolution towards BIM and IPD, and then giving the rights to the client or the ownership that they're demanding, What are the implications of that? How does that work amongst the design team? Where does that go? A huge challenging issue. Payment. We want to get paid. We don't want to get left holding the bag with respect to payment, and how do we deal with it? Termination. I literally was just consulting with the State Board of Engineers about how to interpret a situation where an engineer quit a project because he wasn't getting paid and because the owner was requiring yet another set of revisions to already building department approved plans, and he wanted to quit. But the reality was his contract didn't have a termination clause. We need to have the escape. We need to have the control. We can't just put ourselves in terms of being a captive or victim that's out there. And so I'm going to take a pause for just a moment. I'm going to let Jeff let me know if there are any questions yet before we dive a little bit more into the contract issues. But again, would really invite any of you that can or have an idea, post another contract clause, another subject that you think really fits into the Pareto 6 of the 20%, or the others that you really think is a big driver here.
David, so far, no questions as of yet.
Perfect. That lets me keep talking. I love it. Okay. So I want to talk about the scope of work, and particularly with respect to sub-consultants. The question is, how far do you go? And I want to share an example with you and a story with you. I had a case once where my structural engineer was designing foundation walls for a new fairly high-end renovation of an existing home. And in that project, he was doing the shoring and the foundation design. There was also a geotechnical engineer. That geotechnical engineer did a report. In the report, it indicated that they had not done any soil borings to do the soils report, but it looked at other borings in the neighborhood. And that report indicated that they believed that the groundwater was 18 feet below the project, 18 feet. So water was not going to be an issue. Well, David knows about it because ultimately water was a huge issue. At this site, the water was approximately 18 inches below the surface, and a simple soil boring in the area would have found that. Unfortunately, the geotechnical engineer did not have insurance. The geotechnical engineer had issued its report and was basically insolvent at that point in time. And so my structural engineer was the one targeted. Why didn't you say something? Why didn't you do something? You should have known something, even though you're a structural and they're a geotechnical. And so here on the screen, we have the classic, except for one sentence, language from the AIA C401 provisions. And what I've added is the first sentence, because I think this is incredibly important for sub-consultants to look at and consider adding. Because what we say here is the consultant is only responsible for services within its design discipline and for its agreed scope of work, only in that area. I think that's incredibly important. I think it makes it better and cleaner and creates clear boundary lines. Remember that joint and several liability issue that we talked about? With this, I have an argument in court to avoid that and say, no, we are responsible within the boundaries of what we do, and that's what we are taking place. That does create a greater onus on primes, be it architects or another discipline, to make sure there's no scope gap and to also facilitate the coordination process that we're going to talk a little bit about. But also I want to have this issue here because we are a team. And so that bottom sentence that we have there essentially says that if you see something, say something. We all working together should cease. If we see something, we should say something. But very much like I would be advising you on project job site safety issues and otherwise, if you see something and say something, if it's not your discipline, don't suggest the solution. The person responsible for that area should be the one suggesting the solution for what we are talking about in that particular area. So as we look forward to how to deal with this, this is another version of a different clause that I would use in this particular area. This is one that I have used, and this is one that says we are going to limit our scope of work and responsibility as set forth below or reasonably necessary to complete the services of the prime agreement within the expertise. And so this is one that I would consider using in a scope of work if we're not using a standard boilerplate or the C401 type of language that we have. Now, what do you notice about this? Within all of this, this is all at the sub-consultant level. I'm going to give you something here, and I would love your feedback and comments in the question section, because the next clause we're going to look at, you don't see. It's not out there, but I think as a team, this is a great scoping clause. This is the inverse contained scope of work. Architects are saying, we are going to be responsible for the architectural portion, and team, you're all responsible for your individual segments of the work. I'm trying here to overcome some of that vicarious liability. I am trying to overcome those allegations that I face all the time in litigation, where the architect is quote unquote the quarterback of the project and effectively responsible for everybody. By saying this and affirming it out there and even saying it to the clients, we can change the landscape from that perspective. I think this is realistic. I think this is honest, and this is something that I think we should consider as a group going forward. There's really nothing like this out there. So this is a little bit different than you're going to see. Again, PUA and Arch would love and welcome your comments and feedback back on this, and maybe we can start to make a little bit of a difference in the world if we started to incorporate this type of a clause that we had out there. As I said earlier, one of the greatest contentious points for our design teams is the indemnity and defense. It has been largely regulated or legislated in multiple states in very different ways. Texas is very different from California, is very different from New York, is very different from Florida, and every place in between. And so what we have here is we have disparaging results, where what I believe we have is, as a team, if it's within your scope of work, it's appropriate for the team to expect you're going to step up and, as we say here on the second line, investigate, evaluate, respond to, and defend that issue. We're not talking about defending the party. We're talking about defending the issue as a claim. And then if it turns out that there is liability to a third party arising out of that, you're going to indemnify the other team members. And so what happens here is, just as we are working as a team, collaborating for delivery of the design and the project, if there's a claim, we are working as a team, collaborating and relying upon each other within our various disciplines to respond to what is out there. Important that you don't take on the defense of a party, because that's going to lead to issues with your insurance, and important that you do not take on a liability for indemnity beyond that which you have caused, which should be, if the rest of your agreement is good, with respect to the scope of work and the standard of care. Let's move on to the next topic, which is communication. And communication and doing it effectively is really at the core of how we operate. And it's become much more complicated. Back when I started practicing those decades ago, as I said, that was even before fax machines. And now we have so many means of communication. We have texting, we have email, we have correspondence, we have websites, we have all of those things taking place. And so the first question is, how are we going to communicate? How are we going to do it? And then who's going to have access and authority for it, for the creation of the records and the record retention that's out there? And the one that I really want to focus on here is how do we communicate and the authority for that? Because there can be a proliferation of communication that takes place, and unless we have some guidelines around it, it's hard to know what would happen in all of that. Give you an example. A number of years ago, I was working on a large ferry terminal retrofit project. And for that retrofit project, they took the roof off and they put then on what were supposed to be new design build rafters and trusses to carry the load up at the roof. Supposed to be design build. The design build contractor came and presented at the end of the contract a claim for about $2 million to the owner for changes and upgrades and enhancements. And the owner and the architect and the structural engineer came to the meeting and came to the communications, said, what upgrades? There were no upgrades here. This was design build. You had a performance standard that you were to meet. Everything else was your responsibility. And the contractor brought out three 3-inch binders of emails back and forth between the project team at the draft level and the project manager level. And they said, these are all of the upgrades, all of the directions that we complied with, and that led to the costs. And so it led to a number of things in terms of the question of who has authority, how do we communicate, and how are we going to do all of that? And so as we build a structure for what's taking place, I think to have a committed context for how we communicate is really important. We need to establish it up front in terms of how we are going to handle this. And so one of the things that I have out there is I think that we should have a standard clause. It should be one of our standard procedures that we have. And if we can go to the next slide, we've got an example of it here. And what we're saying here is that except as otherwise agreed in writing, official project communication as to design intent or requirements or contract or project requirements shall be valid only if issued or submitted in writing to the party representatives designated herein. So that means drafts people, CAD people, even project managers, we need them to communicate back and forth because that's how we move projects forward, but it's not official project communication and direction unless it comes at a certain level. And what we say is we're clarifying what that means because it becomes very ambiguous in today's world. And so what we say is that it can include hard copy or electronic communications. I think email is a perfectly valid and appropriate way to do things, but it shall not include text messaging or social media communications. I can't tell you how many cases I now have where I'm having to present exhibits of snapshots from telephones about text message communications, literally pages and pages and pages of them. I have one single family residence project right now where we literally have over 400 screenshots of cell phone messages from cell phones that is supposedly part of the record. It's not a great record. It's incomplete, but it also is something that is out there for control. So I think this is something we should do. Before we go to the next slide, consistent with that, I'm wondering how many firms here have a standard footer to go along with their emails. Do you have a standard communication that's out there? Because if you don't, you know how easy an email can be transferred or forwarded on. I have literally defended dozens of cases involving forwarded emails and claims of responsibility for it. I had a structural engineer who did a structural evaluation of a 12-story building in Oakland, California for seismic retrofit. The owner then took that report, which had been conveyed by email, and forwarded on to the prospective purchaser of the building without any knowledge of the structural engineer. When it turned out there were subsequent issues, the purchaser, after their purchase, sued my structural engineer because they had received the report in an email. I will assure you that that engineer now uses a footer, much like we're going to see on the next slide. Because in a footer like this, what we're going to see is that there is a communication and we're making it clear who is intended and what it's supposed to be in terms of the official communication. If you'd like an example of this, it's obviously here and available in the PowerPoint. I also have a paper out there that the PUA Arch team can provide called Email is a Project Communication Tool, Loose Fingers Sink Ships. But what we're trying to do here is two things. First of all, we're trying to make clear who is the intended beneficiary, who is the intended user of the email, so nobody else should claim a right to it. And if they wipe that out and forward it on, we've got that as our basis of transmittal to show to the court or the judge or the jury. And second sentence is then to go back to what we were talking about earlier in terms of the authority. That is, it is not to be considered a communication as design, meeting, intent, contract, or project requirements unless it comes from the person designated as the project representative within the agreement that is out there. So that's the part that we have on that. So Jeff, any clarification on that prior question or anything on the on this section that people have in questions?
Not a follow-up. There's one that came in and it addresses on page 24. Does this clause limit implied authority agency due to members of the project team? Does that make?
Yes, I understand that. I don't believe it would limit the authority of project team members. It clarifies where their focus and their authority is, but everybody would have the rights to communicate. I distinguish between authority and responsibility, and those are two different things there, but we will follow up more with that later in a follow-up to that question. Okay. Let's go to coordination. And so these are two of the examples of coordination clauses out of the AIA agreements. And I'm referencing AIA agreements because they're very common out there. We could be referencing the DBIA agreements, the Design Build Institute of America. We could be referencing the Associated General Contractors consensus docs. We could be referencing the Engineers Joint Contract Documents Committee, EJCDC docs, but we're focused on this here. And so this is the one that really, I think, sets the tone, because this is what architects get in their agreements. This is what they have as a provision, and I like it, because what it says is we're going to coordinate our services, but we are entitled to rely on those third parties. This is focused on the owners, other consultants that are out there. And then we're going to give prompt notice of anything that's different, but we have that right to rely. Then we have the corresponding C401 provision as to the subconsultants, and that's a very different type of clause that we have out there. And what this one says, same type of, it's kind of an omnibus coordination provision, which says they'll coordinate with those of the architect and the other architects in order to avoid unreasonable delay, orderly and sequential project of the architects, or other consultant services. So inherently, we just became responsible for others. And then there's this omnibus at the end. The consultant shall coordinate all aspects of its design services with the architect and other consultants as necessary for proper coordination of the project. We've talked about limited scopes. We've talked about limited duties. That last clause, can anybody tell me what the limitation of that obligation is? As necessary for the proper coordination of the project. Almost starts to astound about elevated standards. Almost starts to astound in the nature of a warranty. So let's talk about how to really deal with this kind of going forward. And as we go forward with this, I want to suggest, a coordination process that follows this. And that is, we need to establish what the requirements and the criteria are. What are we designing against? What are we working against? Because if we don't know that, we can't coordinate. Then we need to have a process that's out there that's going to document the commit. We're going to establish a procedure, and we're going to require the third sub-bullet there, written confirmation of the coordination for what's taking place on the project and compliance at critical milestones. I'm going to tell you kind of a background story. I am blessed with 4 children, and I knew early on they were all going to go to very expensive colleges. And so I was looking forward to how I was going to pay for that. And I had one client that I thought was going to make a very significant contribution to that, because literally they were good for sending me 4 or 5 claims a year. They were a large architectural firm. They did very high-end projects, and they had 4 or 5 claims almost all the time because their design teams didn't work well together, didn't communicate well together. There were gaps, there were misses, there were errors, there were omissions. And so as we looked at it, we changed the process, and we added that at the end of DD, 50% CD, 90% CD, every consultant on the team was not just going to have a contractual coordination responsibility, but they were going to have to sign off and acknowledge that their documents were coordinated. Just a simple process. It's just confirming that you're coordinated and you're on track for schedule, budget, and design with the other disciplines. All of a sudden, that firm went from 4 to 5 claims a year to literally no claims a year, and I had to find a different way to pay for college. But the point of the story is that a documented coordination process that rises to the level of commitment is so valuable to the team as a whole, and so valuable to that prime that we really want to do all of that. So as we work through the steps to establishing all of this, we kind of have it in the next 4 or 5 slides, a sequence of steps for you to undertake in terms of managing this part of it. We want to have coordinated scopes. Scope gap is the bane of any design team. Overlapping scopes is the bane of any design team. And so we want to make sure that we have done it. From the prime perspective, you want to make sure there are no gaps and establish a format and a timing for the interface between those disciplines. As a sub-consultant, you want to make sure where you are going to rely on others and where others are going to rely on you, so that you can make sure that those are covered, that you have established your right to rely, and that sequencing and procedure is out there so that you know that it's taking place. There's no worse situation than to be in the the second position in that process where you're waiting on somebody else, but because you're not getting it, you can't complete and you can't get on to the next person. So we want to have that out there. The next step is to really take a look at the sequenced coordination. I've kind of talked about that, but what we want to do is we want to get to the point that there is a sequencing. Structural probably before mechanical, mechanical probably before electrical, and sequence all of that through at each stage of the project to make sure that all of that happens in an appropriate way. We want to phase it. We want to make sure that we build the coordination in by phases. It does not work to wait until the 90% CD documents and say, okay, guys, let's make sure we're coordinated. At that point in time, the ship has sailed. It's died in, and if we have issues, we're going to need to solve them and get those accomplished and going forward. And we want to make sure that we begin this process no later than the end of design development, in my opinion, in terms of what's out there. And then we get to the documented elements of it. And that's just, to me, this has become the single most critical element of what's taking place, requiring written confirmation for coordination and code compliance at the critical milestones. Because if everybody on the team signs off that it's done, then you can move forward. Prime consultants, we're talking about this for your team and your sub-consultants, but I'd also really encourage you to think about using this with the owner's other consultants. As you know, in the AIA agreements, one of my favorite things in the B101 is the owner approval at each stage of a project. I call it the waterfall of approval. Well, we can do the same thing with the owner's consultants. And if we get them to sign off, that just elevates the reliance that we have on them as a result of the communications that we have out there. Jeff, pausing here for a moment before we go to cost and changes to see if we have any further questions.
David, I think, the presentation, is filled with a lot of great information. And I think what I can tell is probably a lot of the folks on tuning in are just trying to, absorb everything that you're saying. And right now, I don't see too many questions coming in at this moment, but
Great.
So far, I think it's just a matter of just digesting everything that you're sharing with them.
I know I'm putting a lot out there, so thanks for hanging in there with us, guys. So I want to go to costs and changes. And amongst the design team, those costs and changes can be the biggest point of disconnect. I've been through it many times, guys. It breaks my heart when the design team gets in conflict with each other over costs and changes for what's out there, because we want to be a team and we want to work together. We want to find the right resolution and the right result in it. And if we get into contests between us on the costs and changes, then we're going to develop hard feelings. We're going to undermine the project delivery, and it's going to be a real challenge. That's what's out there. The key issues that I really think we have here that we need to stay aware of are design rights, payment rights or processes, and termination or suspension rights. I'm going to speak just briefly to the latter two. I mean, the first and the third, and then I will go to the other ones. Design rights. There's a lot of variations out there. We talked about it earlier that owners want to own documents. They want to get the electronic versions. They want to have all of that. The reality is that the ownership of the documents and the control over the documents is your best tool to securing payment. It is your best tool to controlling unauthorized changes in your documents. And so if you're going to give up any rights, please at least make it contingent upon payment. Here in California, where I happen to be located, we have a statute for architects that says they can suspend the building permit approvals for a project if they haven't been paid. So hold on to those payment rights as you have them out there. And then having a termination or a suspension right that makes it clear that non-payment or other unauthorized owner changes or anything else that you might want to put in there is a subject and a basis for termination or suspension of your services. You need to have that in there. But I want to talk about kind of the core issue of costs amongst the design team members, because what I'd like to have and what I'd like to suggest in our team model is, as we've outlined it here on this screen, that we are all committing to the payment process with the owner that we have there, that external team issues, that should be paid for by others, be they contractors, neighbors, owners, whatever, that we will work together for that solution and we will solve it together and we will accept that resolution together with each of us sharing our case and what goes on, and provide that we will continue to provide services while all of that is going on for the particular provisions that are out there. What I do have as a backup, and I think I have it on the next slide, is that if that doesn't have, actually go one more slide, please. We'll skip past this one. This is the provision that would build this in. And what it says is you're going to give prompt notice. You're going to give prompt notice if you think there's any issue that has come up for which you should be compensated. And we are going to pursue that payment from the client or the responsible third parties. We're going to accept that as the final resolution. And where I've gone in this, because I think this is appropriate on the team basis for your teams as you have them, except where it is caused solely by one design team member, we are going to rise and fall together with the compensation. If it's a singular cause, a singular issue that people have compensation issues for, and we're not getting paid by a third party, fine, I think it could be paid. But just as in that joint and several, just as in the teaming concepts we've talked about here, I would advocate that if it is in a group dynamic situation that we want to have it be shared amongst us. We suffer, we rise or suffer together, except in that sole responsibility period. The thing I want to go to next and finally is the closeout of the project and managing this closeout issue. We want to make sure that we get all required project sign-offs, and then we want to issue the final invoice and closure letter. This is really important. This is the important thing for sleeping at night, because the final services, the closeout of the project, the sign off and saying we provided our final services starts this magical legal tool called the statute of limitations, the statute of repose. And every day that then goes by, there's a clock ticking, and after a certain period of time in every state, the client can no longer bring a claim against you. Could be as short as 2 years or 4 years or 3 years, and then you can move on from the project. And to have that definitive moment of project closure that's out there is fundamental and critical for what's taking place. So what you want to do is make sure you have all the sign-offs, because if the sign-offs aren't done, then it can linger. Building department sign-off, client approval. I love for other reasons to do a final site walk and sign-off with the client, because that gets us into something that I love that's applicable in many states called the completed and accepted doctrine, which cuts off many third-party claims. But we want to have a closeout procedure for our project, and then we want to document it in a final closeout letter that we have. An exemplar of some of the language, it doesn't have to be complicated. I, as the attorney, if I had these, this as a simple transmittal that goes out with your final invoice, I am in an excellent position to resolve things for you and just go right to the court and say, no, the time is run, the services were complete here, and the time has lapsed for them to bring a claim. That also means that you have to have the discipline, that you don't reopen it, you don't start to re-engage in the services, and if you do something after that, that you're going to have a standard, a different approach. You're going to open up a new agreement, some things like that. One of the side papers you'll see in a moment that I also have out there is limitations of liability done 5 ways. And this would be another connection out there, that you have no liability or responsibilities following substantial completion of the project. That's one of the limitations of liability out there. Doesn't sound like a limitation of liability, but it's incredibly powerful from that perspective in terms of providing that. Let's go to the next slide, please. I can't leave this program without a little controversy and without painting that there is actually a divergence between the professionals on a project. So for example, if you're part of a design team and you have a scope of work that is completed, say 6 months before the project is completed, if you issued your final invoice, that final letter, your clock theoretically starts to run then. I've had many situations where I've, for example, been working for the civil engineer on a project, say for a residential development project, and their scope of work is done largely before the buildings even start coming up out of the ground. And when I can have them final invoice and close out their contract for the project at that point in time, their statute of limitations starts to run and is expired long before the other design team members. So I say that to you to be aware. If you're the subconsultant, close out your project as soon as you can. It might create a tremendous advantage. However, if you're in the prime position, you don't want to be left holding the bag. So if you're in a prime position, I would suggest something like this, which says that the consultant's obligations under the agreement and for the project remain in force and effect until the same time and to the same extent as the obligation of the prime, which basically says we're a team until all of us are done with this project, until all of us can walk away. Different strategies, and I kind of paint that out there for you because we can try to work together, and that's certainly our aspiration of the 5 C's, but I also recognize that people are going to have different points of view. It started at the beginning with whether or not and what provisions from the prime agreement are going to be excluded or objected to or handled differently. And it goes all the way through for different potential points of view, all the way through here to the end where we say that with respect to project closeout and timing, there might be different points of view. I'm going to encourage you to work as a team. I'm going to encourage you to be intentional and strategic and open book about what you do, because if we can all work to follow, adopt, and master the 5 C's, I believe that we can be very successful and professionally satisfied going into the future. With that, Jeff, I will give it back to you. I see we're 1 minute before the top of the hour, so I give it back to you to close out, sir. Oh, if we can go to the next slide. These are just some of the papers that I have out there. You're more than welcome to reach out to your agent. Most of them know me and have access. You're more than welcome to reach out to PUA Arch. They have access to these as well as the other white papers and things that I have written over the years. Thanks, Jeff.
Thank you, David. This has been, extremely informative, time well spent. I know I see there are some additional questions that have filtered in since since we last spoke, and I know that we're going to get those, answer those, address those, so that the folks can have something memorialized that they can reference to. But in my opinion, this has been, a tremendous topic. I think, really valuable, and having you, an encyclopedia and an expert in the industry has just been a tremendous treat for everyone involved. And I'm grateful to have been a part of it, and step in the host for the PUA team. So definitely something that was really worth the hour that we spent together. Now, in terms of any housekeeping items, I think we have all those taken care of. And I think in terms of some of the CE credits, is there anything that you would want to share, David, in terms of how they have to submit them, or is that something that PUA can address?
I think PUA can address that, and if there's any questions about that, I can certainly address how it would happen for either the AIA or for the various state associations for engineers.
Absolutely. So again, we're just about at 3 o'clock. Whole hour of really great information. You're a tremendous resource, and grateful that you spent an hour with us. I've learned a lot, and I'm sure the panelists, the folks that attended, insurance agents, those folks within the the firms that attended, I think got a lot out of this as well. So again, thank you so much.